Hi, Tony here again from Estate Planning Solutions. This week we're going to have a look at inside financial planning and what goes on and how it can affect your estate planning at the other end. So typically you will go to a planner and he or she will do a full fact finder on you, which means they'll take down your details of your assets and your liabilities and your income and what your objectives are, and have a look at your super and your insurances and your investments and make some recommendations. Part of the questionnaire would have been, have you got a will, have you got an enduring power of attorney? You would have answered yes or no, and depending how you answered it will be dependent on what recommendations are made in the documentation that you received. Now, financial planners are subject to compliance checks reasonably regularly, so a compliance officer or manager comes into their practice and will ask for some recent files, and in particular files that have had transactions completed, so that they can make sure that all the I's are being dotted and the T's are being crossed, to make sure that there's no issues in relation to practices. So, what's happened in the past, and I'm not saying all planners do this because a lot of them have tried to advance the estate planning to another level. Still got a long way to go, but typically here's what happens is, when it comes to ticking off the compliance on wills and estate planning, the planners and the planning industry and the big fund managers are all guilty of not really paying the attention that it deserves. So while the compliance manager might have witnessed that on the fact finder you mightn't have had a will and you mightn't have had a power of attorney, and then the planner had recommended that you go and get one done in the document that you received, that's previously been satisfactory. However, things are getting a little bit more complicated, and there's a few cases coming on where planners are becoming liable for mistakes that have occurred, and in actual fact they're in the box seat because they get to know you better than anyone else. The tricky part for them, which unfortunately you become the victim of, or you can become the victim, is that I've asked planners, and as recently as last month, what do you do with your estate planning? Oh, I flick it to the local lawyer because he gives us some work. Well, that sounds great when you say it quick, but it's not good enough, because to me that's just a parasitic relationship. And if the lawyer's not a specialist, but the planner's referring clients to the local lawyer in the hope that they're going to get return business, and they're not qualified specialists, guess who can become the victim? Of course, it's you. So there's one issue that's causing a lot of problems. One of the reasons, or there's a number of reasons that planners have difficulty with this, is because they don't have the knowledge, and it's not a traditional area where they've been paid. So it's been, we'll tick it off for compliance reasons, but it's really, really deserving more than that in today's world. Additionally, it's difficult for them to have the hard conversation with you, the client. It's sensitive, it's confronting. Sometimes you don't want to talk about it, sometimes they find it difficult to talk about, and that's another problem. Their lack of knowledge, you not wanting to maybe talk about it, that is part of the issue. Then the other critical issue is that they'll have a number of clients in their database. So let's say they're looking after a couple of hundred clients. Now, typically, if there's a good planner, there's really got the opportunity, if he's looking after you and your spouse, that they may end up looking after your parents or parents-in-law. And if you have a long-term relationship, your children may eventually become clients. So there's a big dynamic here from the planner in building his practice. And again, very difficult to sit down and pay individual attention to each individual client, and when they're not traditionally getting paid for it, and make sure that the will and estate planning is as good as it can be. So typically it's getting ignored, unfortunately. Then you make another dynamic, and that is that you, the client, might have specific ways that you want to distribute your money, whether it be through superannuation or you have somebody estranged in the family, and you don't reveal this to the planner because you haven't had the conversation, because you find it difficult or they haven't approached you. So all of a sudden you start adding these ingredients together, pressure of compliance on the planner, not particularly being paid for this area in the past, and the difficulty of having the conversation with you or opening up the conversation, their lack of knowledge, in the cases where they're sending off people to a local lawyer for a quick, easy fix, which in the long term is not, because if something goes wrong with your estate planning, a smart lawyer is going to pick up a file, and because we've already discussed how much lawyers like money, and if the planner's been in the driver's seat for your circumstances and should have made an approach to you, or should have attended to something, or didn't make a particular file note, then the planner's professional indemnity insurance may possibly be up for grabs. So I just want to give you a bit of an insight that, you know, you might trust your planner, and there's nothing, and you should, and that's great. But just be aware that a lot of the reasons that you may not have been approached by your planner to this point is because of what we've mentioned in the video. So it might be time to have a look at that area, maybe pick up the phone, do a review, or maybe get in contact with us. But until next time, hopefully that you found that of interest and of use to you.